Okay, so we know we're talking about natural persons here. What type of natural persons? Or is there, we're not talking about intra-corporate transferees, are we? No. So let's look at your schedule. So you have commitments on, go a bit above that. Commitments on business visitors, that's not it. Let's go down. Intra-corporate transferees, that's not it. Go down.
Hang on, this is Marshall Islands. Which number?
63.
Why is Marshall Islands there? They signed in the end, but they never ratified, or what's, but they did sign. I don't know why their schedules are part. Okay, need to tell them that. Okay, go down. So Tonga. Okay, so yep. Go up. So we have business visitors, intra-corporate transferees, contractual service suppliers, independent suppliers, service suppliers, or
Service supplier.
so that would be what corresponds most to this situation. Let's go down again. So I think it would correspond more to this category. The difference is that I think these are natural persons that are employed by a service supplier in, so this is page 63, contractual service supplier. A natural person is employed by a service supplier in another country, and that service supplier sends a natural person, an employee, to provide the service. This is an independent service supplier, so it's a natural person that is a service supplier. Okay, that is a natural person, that is a service supplier. In his own country, he gets a contract and goes to provide the service. So this is what we have here. Okay, foreign lawyer from Kiribati who is self-employed in Kiribati. Admission was refused because the type of legal service that the lawyer from Kiribati wanted to provide was reserved to nationals. Is that consistent with your PACEP Plus commitments? No. Okay, so then you would have to tell your authorities that, that doesn't work. Lawyers coming from Tuvalu and from Thailand were allowed to provide the same services, legal services, in your country. Kiribati complains that you are breaching your obligations under PACEP Plus. Is that correct? So you told the Kiribati lawyer, no, you cannot come and provide the service, even though you should have allowed them, but you're preventing that. And you're, at the same time, you have allowed lawyers from Tuvalu and Thailand to come and provide the same service. Would the fact that you allowed Tuvalu and Thailand constitute a further breach of your commitments or not?
Yes, and
MFN, yes. Very good. So we can open another set of schedule. So this is, well, actually not a schedule, it's a list of MFN exemptions. Yes. So again, there's a general obligation in the agreement to grant most favored nation treatment. Okay. So this schedule contains MFN exemptions of parties for Trade and Services chapter and also for the investment chapter. Yeah, let's go to Tonga. Which page? So in this case, if they grant a more favorable treatment to Tuvalu, for example, that would be a breach of MFN unless they have an exemption that would allow them to do that. So Tonga has a number of MFN exemptions. The first one, you're allowed to give preferential treatment with respect to any bilateral, multilateral agreement signed prior to the date of entry into force of pay surplus. So including for PICTA. So if the preference to Tuvalu comes from PICTA agreement, for example, then you would be, if it fits that exemption, you would be allowed to provide the preferential treatment. Not sure that this would apply in this particular case. In any event, you have to give access pursuant to market access national treatment in your schedule. Let's go down. Is there anything else relevant here? It's just an excuse to have a look at the MFN exemptions, really. So Tonga, and you have a lot of similar MFN exemptions for different pay surplus parties. Any measure that accords more favorable treatment to parties to any bilateral multilateral agreement in force or signed after pay surplus in the following areas: aviation, fisheries, maritime matters. So that's a typical type of exemption you often find. Another one which relates to future agreements that might be signed with other Pacific islands. Should that be the case in the future, you're allowed to do that and to give preferences in that regard, but not relevant for Tuvalu. And then let's go down. So I think this you would find in most schedules. And then audiovisual services, Tonga had a number of MFN exemptions in the GATS that were replicated here. Let's go down. Another one on health and social services. Let's go down. And that's it. So nothing specific to legal services. And I don't think anybody would have anything specific to legal services in their MFN exemption list. Okay, another one, another country, Vanuatu. So let's just have a look to their schedule of commitments first. So this one, Vanuatu would be after, much later. At the end.
Right at the end.
Yeah, like 40, 20, 40, 30 or so.
74.
No, that's another. Let's just have a look at this one first. Yeah. Okay, yeah, go with that. Vanuatu, good. Let's go. Yeah, so they do have commitments on legal services, host country law, okay. Let's have a look at natural person, which number? 74. So yeah, we already heard the discussion. We're talking about an independent service supplier. Up to 90 days. Over a period of 10 consecutive months. Okay, so that's the maximum period of stay. And if it's more than that, then it's subject to some kind of labor market test to show that locals cannot provide that service. Okay. So the first one would be inconsistent, yes. Let's just hear from yeah, let's do the second one, yeah. But I think your MFN exemptions would be like more or less like Tonga, right?
So it's,
I don't think there's a lot of variations. The variations in MFN lists among different pay surplus parties would be because your WTO MFN exemptions would be different, and they were just reproduced with a few additional things. But
The text doesn't say how long he wanted to stay. He just say admission to your country was refused because
Yeah.
reserved to nationals. Maybe because he's asked for a period longer than the 90 days, other than consecutive days.
yeah, well then if that's the case, yeah, then he cannot stay more than 90 days. But from what is written there, I think that he's refused entry for any kind of stay. But yeah, I mean, if he wanted to come for a year, then you can say, no, no. It's not more than 90 days and so on. That you can do. And if he wants to extend beyond 90 days, then you can apply this particular test. Next, Samoa. Let's go here. Let's go, yeah.
Do you want to?
Yeah. So you do have legal services there, but only legal advisory services on foreign and international law. So not legal services with respect to your local law. Okay? And then let's look at MFN, this one. So you do have independent service suppliers, but it's a bit more restrictive. No admission granted after consideration of whether locals can do it or not. So there's kind of a labor market test, that's a restriction. So, but if it's allowed, entry and stay is a maximum of 1 year. But you can have this assessment, and then if you think that locals cannot do it, then you can allow it. If you think locals can do it, then they can refuse it. Okay, so you have this with respect to the services we just saw. So this is the type of flexibility that you have for this category of natural person. Okay? Solomons. And then MFN exemption would probably be the same, I think would be the same as for the others. Solomons. Let's just see if you have commitments. I'm curious on legal services.
Solomon's page number?
342. So you do have legal services committed. Then let's go to here. Which number? So same thing, you do again have the category. If you don't have the category at all, then you can refuse entry, you can say whatever you want. Here, period of stay of up to 90 days within a 1 year period. And then beyond 90 days, up to a maximum of 2 years, again conditional on non-availability of local people to do this kind of, provide this kind of service. So 90 days, they have the right to come provide a service without these types of conditions. Okay? So again, if they were to just deny it, that would be inconsistent with. So, you know, I think PaySurplus also grants a lot of rights for your suppliers that want to provide to movement of natural persons in the region. Because I think for Mode 4, movement of natural person, it goes beyond, you know, in some cases your WTO commitments, especially with these categories for many of you. And, you know, with some guarantees to provide these services in the region, not only to Australia and New Zealand, but also to other Pacific Island countries. And something that in some cases you didn't have in your WTO commitment, so this goes a bit beyond. Or very much beyond in some cases, and also beyond the PICTA or other regional arrangements. Okay? And the last question, a bit more difficult, a bit tricky. Entry to supply the service was refused because your country does not recognize Kiribati qualifications for lawyers. Is that consistent? So a Kiribati lawyer wants to come to, I don't know, Solomon Islands to provide legal services, and then they say, no, you're not allowed. We don't know that you're really a lawyer. We don't recognize your diploma or your qualification. You say you're from the bar in Kiribati. You have qualifications from Kiribati. We don't know what that is. We don't allow you. We don't recognize that as automatically equivalent to our qualifications. Is that inconsistent with your commitments? A very important question, because for sectors like that, legal services, medical services, qualifications are important. And it's not because you have commitments in legal services that anybody says he's a lawyer from another country can just come and provide a service, represent somebody in court. So is it because you have a commitment that you have to automatically recognize anybody from another PACE Plus country as meeting your qualifications? No. Okay? It's not because you take commitments in medical services that anybody with a diploma or the right to exercise as a doctor in another PACE Plus country automatically can get access to your country to provide these services. You don't have to automatically recognize the foreign qualifications. Okay? That's the first part. You don't have to automatically recognize it, just take their word. But you cannot just say no, there's no way you cannot provide the service because you're not from my country and you haven't studied in my country and you don't have any of the qualifications that I officially recognize. You need to allow the foreign supplier you need to have in place mechanisms to allow to verify the competence. Okay, and we'll discuss that tomorrow when we touch on domestic regulation. So it's not because you take a commitment that you need to, accept everybody and assume that their qualifications meet your requirements. Okay, there's nothing automatic, but you need to provide for some kind of a process to verify the competence. You cannot just, you're not from here, so by definition, you don't meet our standards. You need to provide for some way to verify the competence. So of course that can be quite burdensome, that can discourage a lot of suppliers, but that's why there's also recognition agreements whereby countries, try to, where feasible, automatically recognize qualification or certain qualifications from abroad as meeting their conditions. So, lawyers from Australia, I would assume, that meet qualifications to practice law in Australia, in many cases will automatically, I don't know them, but I assume, may be recognized to practice or offer some legal services in New Zealand, because the qualifications will be, in many cases, considered automatically as equivalent. So you can do that, but it's not automatic. Okay? Okay, so any other questions about your schedules? So this was just a way to try to bring it down to a more concrete level, looking at your own schedule. So looking at it, I'm sure other questions may arise. So you see there's a lot of flexibility. You need to look at, because there are different chapters, you need to look at different schedules also for different obligations, MFN, movement of natural person, and then sector-specific commitments and services. Okay? Good. Tea break, or we move on to the next? Huh? Yeah. Okay. Let's do that because just to let them time to set up. Yeah. Okay. Good. Thank you. But if you, again, we're here another 2 days, so have a look at your schedule. It's a big part of your work, what you would be responsible for. You can also look at other PESA Plus party schedules, and then if there's anything, then we can informally chat and discuss those schedules. Okay? Yeah. Good. Thank you. So let's take a quick break, and then we move to the next part of the program. Well, thank you. You're the one who do the answers. I do the questions. It's easy.